tackling the challenges on access to justice during the electioneering period. I'll start with the unavailability of significant remedies. So legal remedies give law legitimacy. And when someone files a lawsuit, they seek compensation for alleged injustice, transgression, or violation of rights that are protected by the law. There's a case that was filed by the MDCT, which is the Movement of Democratic Change in Zimbabwe. The announcement of, there was an election, then the announcement of the first round results were delayed. They filed a suit and the judge never looked into the cause of the delay. Many of such petitions have been upheld and hence no remedies are brought up. So this makes the entire process rendered useless. So there's no need of going to court since no remedies are brought up. Another challenge I'll look at is the delay of cases. It's common to all that justice delayed is justice denied. And so actions leading up to the hearing must go quickly in order for the hearing to be effective. These situations have been so rampant, such that Kenya and Zimbabwe demanded that petitions be given priority and be decided quickly. I'll also look at the lack of an impartial and accountable justice system. There's a widespread belief that the African judiciary is impartial in its practice, and concerns have also been raised concerning these mixed results for judicial independence in election adjudication. In relation to this lack of impartiality and accountability in the justice system, there's a situation in Nigeria where the president of the Court of Appeal turned down a promotion onto the Supreme Court because he believed it was motivated by ulterior motives. Although most countries acknowledge separation of powers, most of the time operations of the judiciary are intervened, hence limiting the access to justice, especially during the electioneering period.
So yes, on the future scope, generally all the election disputes, when there is any election conflicts between two contestants, they always rush to court. And we've seen that there is a lot of backload in the courts because these are the same courts which deal with different matters, family, succession, and all that. So bringing in the election dispute cases will add more to what they cannot already contain. So the question is, what can we do to make it easier for these cases to be handled in a very limited time? So recently we had the legal aid, we had the access to justice in relation to ADR. ADR is the alternative dispute resolution, whereby we use other alternative mechanisms to resolve disputes out of court. So in this case, our paper was discussing on majorly the future scopes in access to justice, which was the alternative electoral dispute resolution. And mostly we were tackling on mediation process, because in mediation, it is where the parties voluntarily enter into an agreement to start the mediation process. So we see that in ADR, there is a win-win situation. So this mechanism will encourage it will encourage more disputants that are in election conflicts to use that mechanism. So in the future scope, we were comparing different countries in Africa, seeing how they have handled or how they've implemented the ADR. Okay. Yes. So we were comparing different countries to see how they have implemented ADR in their resolving their election disputes. So one of the countries, or the pioneering countries, is like Ghana, Nigeria, and Ethiopia. So Ghana, they have the IPA, which is the Inter-Party Advisory Committee. So this committee is more of a liaison group that serves as a platform to engage the EMBs and the political parties for consultation on election matters. Another country is the South Africa and Lesotho. So in South Africa and Lesotho, they also have a similar liaison group or a committee that they come together, the inter-parties and the committees, they come together to engage on the resolution that is pre-election disputes. But then the question is, okay, generally in Kenya we are advised to go to court